Hi all, my name is Caoimhe Kiernan and I'm a PhD student from the Technological University in Dublin. Thank you all so much for attending my presentation today. My presentation is going to be looking at affect, the ideal judge, feminist judgments projects, and the gender composition of judiciaries. During this presentation, I'm going to refer to gender diversity. When speaking about gender diversity, I mean gender diversity from an intersectional perspective, not just gender diversity as it relates to Irish women or white Irish middle-income university-educated women, as I myself am. I'm speaking about gender diversity that includes all women from all walks of society. In conducting my research, I have tried to adopt an intersectional, effective, and feminist framework. I'm also talking about gender as a social construct, not biological sex. This presentation will examine the model of the ideal mythical judge, generally conceived of as white and male, and what its implications are for the gender composition of common law judiciaries. If the mythical judge is perceived as male and white, can global feminist judgments projects and the affects they inspire help to mitigate this perception and influence gender diversity in common law judiciaries? The model of the ideal judge was first posited by Ronald Dworkin, American philosopher and jurist, in 1975. The ideal judge inhabits the traditional legal imagination, akin to the Herculean superhero of ancient mythology. This figure is male, and as pointed out by Eric Rackley in 2002, performs superhuman feats in human form. Rackley pointed out that while we expect judges to have no personal identity, this expectation of judges as supernatural beings with flawless judgment traps them. It encourages them to suppress independent decision-making. This wonderful paragon of judging was created to challenge several schools of thought. First, Dworkin believed that law as rules formalists, purists, viewed judges as robots who applied laws without interpretation. Secondly, Dworkin challenged the view of legal positivists, that judges overlooked moral ideals while making decisions. Judges had to draw on moral ideals to make sense of the rules that they were applying. Finally, in response to legal realists and critical legal scholars, Dworkin defended the view that all judges simply worked from their own preferences, that they were bound by legislation and precedent when deciding cases. Before approaching his first case, the heroic Judge Hercules could build a gigantic, overarching theory good for all seasons. In response to Dworkin's work in 2002, Rackley presented us with a juxtaposing view. If the male judge is Hercules, then the female judge is the Little Mermaid, made famous in the story by Hans Christian Andersen. As such, the woman judge is almost a contradiction in terms. Rackley stated that she's so deviant that she is inevitably subject to an impressible desire to reform. Like Andersen's mermaid, she's induced to deny herself and sell her voice. Her dangerous siren call is silenced, and the silence in difference is lost. Rackley posited that the women judge cannot easily step into Hercules' shoes or wear his bespoke superhero suit. Women judges are expected to make decisions as if she had the same perceptions and experiences as their male counterparts. Rackley highlighted that women judges are excluded and marginalized as the other. She revisited this notion in 2013. She stated that the experience of being a woman judge is still often one marked by isolation, hostility, and mistrust. Although the judiciary no longer performs intellectual somersaults to keep women out, a growing collection of tales or anecdotes suggests that the judicial climate remains somewhat chilly towards them. In her book, Rackley explored these stories of women judgments. They're treated in small ways, but the difference was also noticeable. Rackley acknowledged the effective potential of these women judges' stories. They could be used to incite feelings of anger and disappointment in order to garner political support for change. Her view of the woman judge existing in two separate worlds and belonging to neither is supported by Byrne and Barron, who stated that to speak as a judge is to speak in a way that cannot be bracketed. One cannot speak as a woman judge or even as a woman judge. Judge must stand alone if judgment is to carry weight. She also highlighted that the woman judge will face temptation to repress signs that she's different, to totally assimilate to the behaviour and mannerisms of her female colleagues. Rackley's view of the default judge, Judge Hercules, is that he was anonymous, dehumanised, impartial, authoritative, and intrinsically male. The judiciaries have, since their modern origins, been populated by white men with similar educational and social backgrounds, often with similar political ideologies. And that encourages us, the public, to associate judges with those who possess these attributes. We become attuned to judges which fit this mold and automatically other judges who are in any way different. In 2020, Hickey noted that while Rackley makes an important and fundamentally persuasive argument, he believes that it was also problematic. He believes that her understanding of the ideal judge Hercules was flawed. He noted that Hercules wasn't some static notion of what an ideal judge should be, but an open and ever-evolving idea, not merely capable of, but positively disposed towards accommodating the kind of anti-patriarchal judgments in the feminist judgments projects. So what do judiciaries I look at currently look like in terms of gender diversity? Well, the Irish judiciary has 168 judges across all levels of seniority, but not including tribunals. 39% or 66 were women, and 61% or 102 were men. In Scotland, in 2019, 25% of the judiciary were women and 75% were men. But Scotland doesn't publish the breakdown of gender roles, including any demographics about their judges. So my knowledge base was a little bit flawed here. In the South African judiciary, there are 249 permanent judicial roles, and 63.8% of these were held by men, or 159, and 36.2% were women, or 90. Finally, in the Canadian federal judiciary in 2021, there were 663 men, or 55%, and 543 women, or 45%. Now, the number here also includes 292 supernumerary judges who are judges who have a reduced workload over a certain age. So 65 years old had to have 15 years judicial experience, and 70 years old had to have 10 years judicial experience. Now, what do I mean when I talk about affect? Affect is defined in the Merriam-Webster dictionary as a verb which means to produce an effect upon, or a noun which means the conscious subjective aspect of an emotion considered apart from bodily changes. Using the latter definition of the word, we understand affect as an aspect of emotion, not produced by the body, but by the mind, and experienced within both the body and the mind. Affect theory then is the study of affect. Affect extends beyond mere emotion. It's a type of good instinct or innate physical urge felt within the body but inspired by events both outside and inside the body. It's found at or near the very beginning of something, concerning the first stirrings of any movement. Affect theory can be used as a framework to understand change, which is how we're trying to use it here. Sylvan Tompkins introduced the idea of 9 innate affects experienced by all people, such as rage, joy, and shame. Affective potential can be found in nearly all things, even the most mundane of objects. Anything that evokes affect in others has affective potential. Affect is also a social phenomenon. Affects can be felt and experienced by society as a whole. Scholars have used affect theory when exploring gender-related issues. Pedwell and Whitehead explain that feminist scholars have been at the heart of these engagements with affect theory, in part because for some, feminism itself is a politics suffused with feelings, passions, and emotions. What then does affect have to do with the feminist judgments projects? As I mentioned, affect is something that extends beyond mere emotion. It's felt within the body, but is inspired by events outside the body. For this paper, I'm using affect theory as a framework to examine the potential affectiveness of the feminist judgments projects. Global feminist judgments projects are being organized by legal scholars to reimagine important judicial decisions using feminist theory. The aim of the projects is to see how important legal issues might be decided differently by decision makers who apply feminist perspectives. Participants in the projects were asked to reimagine themselves as practicing judges, bound by the same law, doctrinal strictures, conventions, temporal knowledge, and evidence as the original decision makers. The projects aim to apply feminist theory knowledge and to critique real-life legal cases to show how the outcome of cases could have been completely different, even while still within the bounds of the legislation and jurisprudence of the time. Using an affective framework when reviewing the outcome of feminist legal projects, one could clearly see the effective potential of these rewritten forms of communication. They inspire rage, anger, and sorrow as we learn how different outcomes could have been achieved had the judges simply utilized a different perspective. They also inspire hope and joy as we contemplate how things can be different in the future. By identifying the affects inspired by the projects, one can see how these can be practically drawn upon. Hickey in his 2020 article seems to correlate the feminist judgments projects with Gilligan's ethics of care theory and mentions concerns around the feminist judgments project's essentializing of men and women. The arguments about women judges speaking in a different voice are based on the theory that once women become judges, they will actually make a difference when they get there because of their biological difference and the different value systems they have. Women will make different or even better decisions than male judges. These arguments draw on Gilligan's ethics of care theory, that women are more empathetic, more emotional, that women speak in a different different voice than their male counterparts' voices. Her essentialism theory underlines the idea that women make better caregivers and are more suited to caregiving roles than their male colleagues are. Justice Sandra Day O'Connor, the first woman on the US Supreme Court, said the very question of whether women speak with a different voice is dangerous and unanswerable. Baroness Lady Brenda Hale, the first female president of the Supreme Court of England and Wales, argued in 2001 that women do not want to claim that they look at things differently from men, partially because it would make them less well qualified to be judges. Hickey believes that the projects have drawn heavily on Gilligan's ethics of care theory when identifying goals and approaches for the projects. He equates Hunter including women's experience in legal discourse as a criteria for writing like a feminist, as a validation of Gilligan's essentialist theory. It's been noted that the signature achievement of these projects has been to demonstrate that judicial decision-making is rarely detached from personal background and experience, and the judicial interpretation is never purely neutral and objective. If judicial decision-making is influenced by the real-life experiences of the judge, then it could be argued that judging is both influenced by affects experienced by the judge and creates affect in those who read the decision. This, I think, shows not, as Hickey argues, that the authors of these projects are believers in Gilligan's essentialism argument, but the authors of these projects firmly believe in the different perspective argument. By looking at the feminist judgments projects, one can see that by rewriting previous legal judgments, using a feminist legal framework and critical legal theory, judges can come to different decisions simply by using a different perspective. These projects are not a byproduct of essentialism. These projects are written, however purposefully, to inspire societal affects through using a different perspective. Though the feminist judgments projects inspired by the feminist judgments projects and inspired by the affects they create, judicial appointment committees can see the value in diverse judicial perspectives. The necessity of a diverse judiciary doesn't have to be an essentialist argument. It can be one of perspective, fairness, and ensuring public confidence in the judiciary. When writing about the Canadian judiciary, Crandall highlighted this when she said that there are a number of arguments in support of judicial diversity, but arguably the most compelling focuses on the issues of legitimacy and fairness. Recall that it's critical for the public to believe that the work of the courts is fair and impartial. As the oft-repeated phrase goes, not only must justice be done, it must also be seen to be done. Crandall also highlighted that a lack of diversity in the judiciary can act to undermine the public's confidence in the court system, reducing the legitimacy and authority of that judiciary. She outlined that there's a lack of fairness with excluding qualified candidates who also happen to be members of underrepresented groups from the bench. An example of this can be seen in 2012 in Canada. There was an outcry when Peter MacKay, the Canadian Prime Minister at the time, claimed that the diversity in judicial appointments was in decline as too few candidates were applying to be judges. While national statistics were not publicly available to verify the veracity of his claims, Ontario had been recording and publishing the gender of judicial applicants since 1989. In 2012, women had made up 58% of Ontario's provincial courts. MacKay received significant criticism for trying to place the blame on underrepresented groups instead of on his own government's judicial appointments procedure. This incident highlighted the benefit of collecting statistical data on both judicial appointees and judicial applicants. It allows us to understand whether judicial diversity is a problem of supply, demand, or possibly both. In 2016, the federal judicial appointments process in Canada was entirely overhauled. All of the Canadian federal judicial advisory committees were disbanded and then reformulated through a standardized process, ensuring the diversity of Canada was taken into account. All members are provided with training on diversity, unconscious bias, and assessment of merit. All judicial applicants are now asked to fill out a voluntary demographics questionnaire related to diversity, and judicial advisory committees who previously only had to consider 2 criteria when evaluating judicial applications, professional competence and experience, and personal characteristics, also now have to consider diversity. Inspired by the Canadian judicial appointment reform and the affects inspired by the Feminist Judgments Project, judicial appointment committees, governments and legislators in Ireland, Scotland and South Africa would do well to engage in meaningful reform of their judicial appointments process. Finally, we get back to the point of the ideal judge. So who then is the female judge in 2021? Is she Hercules, the ideal robotic judge with flawless legal interpretation? Is she the Little Mermaid, walking on wobbly legs with no voice of her own, wearing the vain emperor's clothes? I don't think she's either anymore. The Feminist Judgments Project have shown that it's less about the gender of judges and more about the perspective they bring to judging. A woman judge can have an anti-feminist perspective, just as a male judge can have a feminist one. When speaking solely about the female judge, we have to take into account their unique life experiences and their perspectives. Women, including women judges, are overwhelmingly burdened by care work, including child-rearing responsibilities and caring for family members. Women are less likely to prioritise their careers and more likely to suffer fatal car crashes. They're more likely to suffer intimate partner violence. We live entirely different lives than a lot of our male counterparts due to the gendered nature of our society, which we all exist in 2021. To survive in our society, women keep their keys in their hands when walking home at night. To succeed in a judicial role, a judge has to prioritise fairness, equality before the law, decision-making and knowledge when acting in their role. A woman judge, therefore, exists in two worlds, the world outside the judiciary and the world of the judiciary. Women are judges, and judges also happen to be women. The woman judge belongs neither to one world or the other, but she does belong in both. She reminds me of the story of Persephone, the goddess of the underworld, who lived half her time below the earth and half her time above it. Unlike the Little Mermaid, Persephone had a voice and a perspective and used her time in both worlds to develop and use both. It's up to us to decipher whether she was abducted from her day-to-day life to serve as a judge, or vice versa. Judicial appointments committees don't need to discount the idea of Hercules as a judge. They just need to be open to the idea that Persephone might also want to be a judge. Finally, we come to areas of further research. I'm going to be exploring the duality of judging, how Persephone could be a perfect example of the female judge in 2021. It's also my intention to employ an intersectional effective feminist framework to further explore the affective potential of the Feminist Judgments projects, to undertake an empirical analysis of Irish judicial opinions and case law, which I'm currently doing, to perform interviews with members of the judiciary, and to conduct surveys with members of the legal profession regarding the importance of gender diversity within the Irish judiciary. Thank you all so much for your attention to my presentation, and I welcome any questions you may have during our Q&A session later today. Please do not hesitate to email me, find me on Twitter or on LinkedIn should you wish to get in touch. Many thanks again for your attention. Finally, these are just some selected references. If you wish to have a full copy of my bibliography, please don't hesitate to contact me.